Hey guys, David Tarras here, head of the Federal Criminal Defense Practice at the Rossen Law Firm. What we're going to talk about today in this video is the bond process in federal court. It is different than how the bond process works in state court, and it is something that we can really capitalize on if we're hired early enough in the process. Now, every case is different. Every potential client and client that comes to us at different stages. But one of the things that we can be very effective with, and that we are very effective with, is being able to negotiate a bond in federal court before you have what's known as your initial appearance, or is more commonly referred to as first appearance, as it's called in state court if you're more familiar with the state court system. In the federal bond process, there are really three main types of bond. What we're going to be going for and the ideal, best kind of bond that you can have is what's known as a signature bond. It is the equivalent of a state court own recognizance bond. Sometimes it does require a co-signer on the signature, but what this signature bond really is you are swearing, our client is swearing that should they violate any condition of their release, such as picking up a new crime. Sometimes there is a substance abuse evaluation, drug testing, more rarely with a signature bond, but it is possible that there can also be a home confinement, house arrest portion of that. But the best type is just signing for some monetary value. So it could be a $50,000 or $100,000 signature bond. And what you're saying is that as long as you don't pick up any new crime or violate the terms, you don't have to pay anything to be released. You sign some documentation that your attorney, myself, would help you go through, present to the court, and you get out that same exact day. You don't have to pay any money to a bondsman. You don't have to post anything in order to do so. Now, the earlier we're hired in a case, the earlier we can start pre-negotiating and negotiating with the U.S. Attorney's Office for a signature bond, for a favorable bond. It's a big difference with state court and federal court. Usually, not always, but usually, you will be able to have more of a heads up of that first appearance hearing. Maybe an investigation has been ongoing for some time, and the U.S. Attorney, Assistant United States Attorney decides to go to a grand jury. If you have a lawyer soon in that process, we can be in open communication with the prosecutor that, God forbid, we're not able to prevent charges, then we can at least negotiate for a time for our client to voluntarily surrender to the court and to the marshals with us present, with your attorney present, to negotiate a signature bond is the best case scenario. The next step up from a signature bond is something known as a 10% bond, also known as a cash bond. What that is there's a dollar amount set on the bond. Let's say it is a $100,000 cash bond. Our client, the defendant, may have to, in that scenario, post, or will have to, in that scenario, post, unless someone is posting for them, a 10% of the monetary amount to the clerk of courts, the federal clerk of courts. That is different than going to a bondsman, where the bondsman keeps your 10%, and which is more common in state court, and they post the remainder. In federal court, the 10% is posted by our client, and you do get that money back when the case is concluded, which is great. Not as ideal, of course, as a signature. It does involve putting money down, but it's the next step up. And then the third main category of bonds is what is most commonly referred to as a secured bond, or also a corporate surety bond. A corporate surety bond requires a bondsman, and unlike in state court where it's 10%, or like in federal court if it's a 10% cash bond, it's 15% to the bondsman, and the entire amount of the bond does have to be covered by collateral as well, and that has to be presented to a bondsman. That's something that an experienced federal criminal defense attorney can work with you on. That can also be pre-negotiated if the federal prosecutor is requiring that, we can always still have a hearing called a detention hearing challenging the bond. And at the initial appearance as well, we can make arguments as to what we, as on the defense, believe is the appropriate bond. Very often, though, we do want to try and have everything pre-negotiated and do it on the front end, so you spend the least amount of time in court and possibly in custody as well. So the bond process, that's a very simplified version. It is nuanced. There's a lot that can be done by a federal criminal defense attorney, like the attorneys at the Rossen Law Firm, to help you or a family member through that initial process before the rest of the case plays out, and we exercise all of our defenses on your behalf. So please give us a call if you are in a situation where you're arrested for a federal offense, or if you are under investigation and were retained and become aware that charges are forthcoming. We can start that bond process right away. So call us if you're in that scenario. Thanks.